disputes relating to maybe passing off, where one business almost looks like the other, the names are similar. Sometimes you have this situation where somebody works at an establishment, a small business establishment. Somebody has come with a creative idea to do something. He gets an employee who works with him for 6 months in the startup, and then gets to know all the things that there are to know in that business. And then 200 meters down the street, he also starts a similar competing business, and therefore these people see each other as
competitors.
Beyond competitors, it's like you are almost stealing my idea or something, and therefore instead of a healthy competition, you see some enmity, backbiting, and so on. These are some of the...
But is it wrong if I work under you for a while and I think that I've understudied you well enough, and whatever it is that you are into, I can replicate to do same under a different brand or name? What is the big deal?
Well, it depends on each case. In fact, in some situations, if we're being formal, there are certain types of businesses or startups where they require non-disclosure, and they actually require their employers not to take similar employment with their competitors within a year or two after they have left, and so on and so forth. So depending on the situation, if somebody is coming up with a novel idea and you are going to get access to the novel idea because you are an employee and they are telling you, what they are using and the steps they are taking to become competitive, then they could at law require you not to go into a competing business with them. But more to the point, the point I was making for our listeners is the thinking through how to resolve the business disputes like you asked. So if you have, let's say somebody has supplied you with goods for one reason or the other, you were unable to pay, but you have about 3 or 4 different suppliers. You are still working. Prospects are good. It's just that maybe a contract that you were relying on, you've not been paid because the person also hit a snag somewhere. Now, if you were to go to court, or you allowed that dispute relating to the non-payment to go to court, it is likely that all your other suppliers to whom you owe money will also hear, and they panic, and they may also start demanding their money. But if you went through the alternative dispute resolution means and you sat down in-house with this person you owed money to, and you found a way of resolving it, assuring them you would pay and put in practical measures to pay them, you see that would be quiet. And as it were, the other people may not come in. Another thing too, which is a big risk when businesses start fighting in courts, which is public, is that they reveal their trade secrets and sometimes profitability levels. There are some businesses, when you see the people going about that business, because some businesses are dirty, quote and unquote, by being in it, you always have to look unkempt because it's dusty, it's this and that. People don't look there. But you go to courts and let your lawyer start cross-examining as to percentages of profits. By the time you leave the courtroom, somebody with big money, bigger than yours, would be investing in it and driving you out, because now they realize that when you invest 200 cedis in this business, you can get 1,000. And therefore, because people have money sitting in their pockets looking for opportunities. So if you go to court and you are revealing your business secrets in the public of the courtroom, by the time you come out, either your reputations are destroyed or your business secrets are out there. That's why we recommend alternative dispute resolution for startups and small businesses, so that they can resolve their disputes in private with some confidentiality.
But no,